An unusual silence settled over the Supreme Court's chambers as Representative Jasmine Crockett stood at the attorney's podium. Her posture remained confident despite Justice Samuel Alito's questioning that had now reached its third interruption in barely 5 minutes. For months preceding this moment, the conservative justice had been generating headlines with public speeches that raised serious concerns about his ability to maintain the impartiality expected from someone serving on the nation's highest court. On this particular morning, as Crockett methodically presented her reasoning in a landmark case challenging voter access restrictions, Alito's mounting frustration had become impossible to ignore. "Congresswoman, that interpretation simply doesn't align with constitutional text," the justice declared dismissively, cutting off her sentence mid-thought. The crowded gallery held its collective breath as Crockett ceased speaking, her expression revealing quiet determination as her eyes met the justice's directly. She reached for a leather document that had remained untouched on the table before her, extracted a single set of papers, and when she began speaking again, her measured cadence instantly seized every person's attention in that historic room. What unfolded over the next half-minute didn't merely silence Justice Alito. It exposed a fundamental truth that would send shockwaves through America's federal court system for years to follow. Long before this watershed confrontation, Representative Jasmine Crockett had built a formidable reputation as a constitutional scholar beyond her current role in Congress. Her background included extensive experience as a public defender and civil rights litigator who specialized in protecting voting rights, giving her a command of constitutional principles that few politicians could rival. Though she now held elected office, Crockett had preserved her law license and occasionally accepted cases involving extraordinary constitutional questions, including this direct challenge to a state's severely restrictive voting legislation. Meanwhile, Justice Samuel Alito had been making waves with progressively more partisan public statements during a recent gathering of the Federalist Society. His comments suggested deep skepticism about expanding voting access, causing observers to question whether he could approach cases like today's with the required neutrality. Multiple ethics complaints had been submitted. Yet, the Supreme Court's absence of any enforceable ethics framework meant these concerns remained essentially unaddressed. The founding generation understood that electoral systems required protective mechanisms, Alito had proclaimed in a speech delivered just 3 weeks earlier. Contemporary efforts to portray reasonable security protocols as discriminatory would have bewildered them. These remarks drew swift condemnation from constitutional scholars representing every ideological perspective who argued the justice appeared to be announcing his conclusions before cases even reached oral argument. Behind the scenes, Crockett had been conducting exhaustive preparation that extended far beyond standard legal strategy. She had been diving deep into historical archives, researching the original sources and debates that shaped the very constitutional amendments Justice Alito claimed to be defending. As someone who served simultaneously as both Congresswoman and accomplished constitutional attorney, she brought an unusual perspective to questions sitting at the intersection of law and governance. The courtroom was packed beyond capacity. Legal scholars, civil rights advocates, and journalists filled every available seat. The Chief Justice had authorized extended argument time given the case's profound significance, and anticipation ran high throughout the chamber. As Crockett approached the podium to begin, whispered conversations predicted that Justice Alito, notorious for his aggressive questioning of progressive advocates, would likely dominate the entire proceeding. The stage was perfectly set for what observers expected would be yet another illustration of the increasingly polarized dynamics that had come to define the nation's Supreme Court. When Congresswoman Crockett commenced her oral presentation, tension radiated through the Supreme Court chamber like electricity through copper wire. Unlike previous attorneys who had been repeatedly thrown off balance by Justice Alito's questioning tactics, she opened with a clear, emotionally resonant story about the tangible human consequences of the voter restriction law under review. "Chief Justice, and may it please the court," she began. Her delivery was both assured and precisely calibrated. "The franchise represents the cornerstone upon which every other constitutional protection we possess is constructed. When 53,000 eligible citizens in Jefferson County found themselves unable to exercise their right to vote last November, we witnessed not merely individual tragedy, but a systemic constitutional failure. Several justices nodded subtly as she established the human dimension before transitioning into constitutional analysis. The state contends that Article 1, Section 4 grants essentially unlimited discretion in establishing electoral procedures. This argument, however, completely disregards both the 14th Amendment's equal protection mandates and the historical circumstances surrounding Justice Alito cut in, his tone conveying dismissal. The textual language of Article 1 is abundantly clear. The Constitution assigns state legislatures primary control over election administration. Isn't your actual disagreement with the constitutional structure itself? The interruption came merely 90 seconds into her opening, but Crockett's composure never wavered. Justice Alito, I'm not challenging the Constitution's design, but rather offering a complete reading of its provisions. Article 1 cannot be interpreted in isolation from the Reconstruction Amendments, which fundamentally transform the balance between federal authority and state discretion regarding elections. She proceeded to systematically explain how the 14th and 15th Amendments specifically impose constraints on state election powers, citing both Reconstruction-era congressional records and Supreme Court precedents. Justice Elena Kagan indicated appreciation for the historical framing, while Justice Brett Kavanaugh took careful notes as Crockett constructed her argument for why the particular identification requirements in question impose disproportionate obstacles on minority voters. Justice Alito interrupted once more. These amount to minor inconveniences, counsel, not violations of constitutional magnitude, he stated emphatically. Every electoral regulation creates some level of burden. Absent evidence of intentional discrimination, which your record fails to establish, these policy determinations belong with state legislatures, not federal courts. Crockett smoothly redirected the discussion. With respect, Justice Alito, this court's precedent in Anderson v. Crabe, in Burdick v. Tekush established that even without discriminatory intent, regulations that disproportionately burden the fundamental franchise must be justified by substantial state interests. The evidence we've submitted demonstrates the state's interest in preventing electoral fraud is self-evident, Alito interrupted for a third time, his growing frustration increasingly apparent. The Constitution does not guarantee convenience. Congresswoman, it distributes authority, and in this domain, that authority resides primarily with state legislatures. His reference to her congressional title, rather than the customary counsel, raised eyebrows throughout the gallery, an unusual departure from courtroom protocol that seemed calculated to emphasize her political position rather than her capacity as a legal advocate. Crockett paused, her expression resolute as she faced Justice Alito directly. The Constitution, Justice Alito, is not merely an authority distribution document. It's a framework for constraining power to protect fundamental rights. But since you've raised questions about constitutional design, I believe the historical record demands closer examination. She opened the leather portfolio that had remained closed until this precise moment and removed a single document. I've undertaken extensive research into the original sources that informed the Reconstruction Amendments, particularly regarding state election authority. Justice Alito, you've suggested multiple times today and in recent public forums that the Constitution's original understanding grants states nearly absolute control over voting procedures. Her voice remained steady, but now carried unmistakable authority. However, I have before me the complete congressional debate transcripts from 1869 when Congress was deliberating the 15th Amendment. She lifted the document, its highlighted sections visible even from a distance. Senator Oliver Morton, one of the amendment's principal architects, stated explicitly that its purpose was, and I'm quoting directly, to place the power of safeguarding the right to vote in the proper hands of the federal government where it rightfully belongs rather than leaving it to the legislative whims of states that have demonstrated themselves unworthy of this responsibility. The chamber became absolutely silent. Justice Alito shifted perceptibly in his chair as Crockett continued without pause. Furthermore, Representative James Garfield, who later served as president, declared during these debates that the moment had arrived to establish a constitutional principle that would supersede all state regulations burdening franchise exercise based on conditions unrelated to the Voting Act itself. She turned to a second page in her document, most directly relevant to today's case, Senator William Stewart, who drafted substantial portions of the amendment's language, specifically addressed whether states could impose procedural obstacles that would effectively nullify voting rights. He stated, and again, I quote, "We are establishing not merely a prohibition against explicit racial barriers, but an affirmative principle that the right to vote must be practically accessible to all citizens regardless of their station." Several justices, including Chief Justice Roberts, leaned forward with visible interest as Crockett handed copies to the clerk for distribution among the bench. Justice Kagan exchanged a meaningful glance with Justice Sotomayor that communicated recognition of the moment's significance. "These are not obscure historical footnotes, Justice Alito," Crockett continued, her voice gathering strength. "These are the explicit statements of the individuals who authored and ratified the Reconstruction Amendments. The same constitutional provisions you've cited repeatedly today. They directly contradict the narrow interpretation you've advocated both in this courtroom and in your recent public appearances." Justice Alito's expression tightened, discomfort flashing across his features as he grasped the implications of what she was revealing. He leaned toward his microphone to respond, but Crockett pressed forward, her tone measured yet firm. "The historical record leaves no ambiguity. The Reconstruction Congress specifically intended to limit state discretion over voting procedures precisely because they recognized that facially neutral regulations could be weaponized to undermine the franchise. They did not merely prohibit explicit discrimination. They established an affirmative federal interest in protecting meaningful ballot access." She pivoted to the specific evidence in their case. In Jefferson County, 83% of voters turned away under this law were minorities, despite minorities comprising only 30% of the county's population. This statistical disparity alone would have outraged the 15th Amendment's framers, who explicitly rejected the notion that states could use procedural mechanisms to accomplish indirectly what they could not do directly. Justice Barrett, who had been observing the exchange quietly, spoke for the first time. "Congresswoman Crockett, these historical sources are quite compelling. How would you apply them to the standard of review in this case?" "Justice Barrett, I appreciate that question," Crockett responded. "These sources demonstrate that when reviewing voting regulations, this court should apply heightened scrutiny whenever legislation results in significant disparities in ballot access, regardless of provable intent. The Reconstruction framers understood that the franchise is preservative of all other rights and requires special protection from procedural encumbrances." Justice Alito attempted to redirect. "These are interesting historical observations, counsel, but they don't supersede Article 1's plain text, which remains with respect." "Justice Alito," Kagan interjected calmly, "these are not observations. They are authoritative explanations of constitutional meaning from those who wrote and ratified the amendments, and they directly address the relationship between Article 1 powers and later amendments designed specifically to constrain those powers." She moved to her concluding point. "The Reconstruction Amendments fundamentally transformed our constitutional architecture, creating new limitations on state authority precisely in the voting rights context. To read Article 1 as though these amendments don't exist is not textualism or originalism. It's selective constitutionalism." The phrase landed with quiet but unmistakable force. Several law clerks seated in the back rows visibly reacted. Even Justice Thomas, who rarely spoke during arguments, raised his eyebrows noticeably. Chief Justice Roberts, recognizing the moment's significance, extended Crockett's time by 5 minutes, a rare gesture signaling the profound impact her argument was having on the court. Crockett then methodically connected these historical insights to the specific evidence before them, demonstrating how the state's voter identification law imposed precisely the kind of procedural burdens the Reconstruction Amendments were designed to prevent. "In conclusion," she stated, her gaze encompassing the full bench, "this case is not about convenience versus security, as some have characterized it. It's about whether we honor the constitutional commitment made through the Reconstruction Amendments, a commitment ensuring that the right to vote remains meaningful for all citizens, regardless of race, wealth, or status." She gathered her materials as her time expired, delivering a final statement that left the courtroom in stunned silence. The framers of the 15th Amendment would recognize precisely what is happening in Jefferson County today. The question before this court is whether we possess the constitutional courage to see it as clearly as they did. A collective intake of breath swept through the chamber. Justice Alito sat motionless, the historical evidence having undermined not just his questioning in this case, but positions he had been advocating publicly for years. Other justices exchanged glances, communicating the weight of the moment they had just witnessed. As Crockett returned to her seat, the usual murmurs that follow powerful arguments were absent. Instead, the Supreme Court chamber remained in reverent silence, absorbing the rare moment when constitutional history, legal reasoning, and moral clarity had aligned with such undeniable force. The aftermath of Congresswoman Crockett's historic Supreme Court presentation extended far beyond the immediate case, fundamentally reshaping constitutional discourse and revitalizing voting rights jurisprudence for years ahead. Within days, legal publications were dissecting what many termed the Crockett Brief, not just her oral argument, but the comprehensive written submission, expanding on the historical evidence she had presented. Harvard Law Review dedicated a special issue to examining the Reconstruction-era sources she had uncovered, with prominent originalist scholars acknowledging the significance of materials overlooked in previous voting rights litigation. What Crockett accomplished was extraordinary, wrote Professor Akhil Amar of Yale's Law School in The Atlantic. She employed originalist methodology to demonstrate that the Reconstruction Amendment's original understanding was far more protective of voting rights than many modern jurists have recognized. It's a masterclass in how historical evidence can illuminate constitutional meaning. The impact on the court itself became evident 3 months later when the decision was announced. In a surprising 6-3 opinion with Chief Justice Roberts writing for the majority and Justice Barrett concurring, the court struck down the contested restrictions while establishing a new, more protective framework for reviewing voting regulations. When voting regulations produce demonstrable disparities in franchise access, Roberts wrote, courts must apply heightened scrutiny to ensure state interests are both compelling and cannot be achieved through less burdensome means. This standard flows directly from the original understanding of the Reconstruction Amendments, which fundamentally altered the constitutional balance between state discretion and federal protection of voting rights. Most notably, Justice Alito authored a concurrence rather than a dissent, a rare retreat from his previously rigid positions on state election authority, while maintaining that states retain significant discretion in election administration. He acknowledged that the historical records surrounding the Reconstruction Amendments, more fully illuminated in this case than in previous litigation, establishes meaningful constraints on that discretion. When voting regulations significantly impact ballot access, legal observers immediately recognize the seismic nature of this shift. Nina Tottenberg of NPR called it the most significant recalibration of voting rights jurisprudence in decades. While legal scholar Richard Hazen wrote that Crockett didn't just win a case, she changed the constitutional conversation around voting rights. For Crockett herself, the Supreme Court argument marked a defining moment in her already distinguished career. Though she continued serving in Congress, her constitutional expertise made her a sought-after voice in subsequent voting rights litigation nationwide. Law schools reported that applications from women of color increased significantly in the following academic year, with many citing Crockett's courtroom performance as inspiration. What Congresswoman Crockett demonstrated wasn't just legal brilliance, explained Cheryl Mills, former director of the NAACP Legal Defense Fund, in a public forum at Georgetown Law. Her lived experience as a Black woman from the South, combined with her legal training and political understanding, allowed her to see connections in our constitutional history that others had missed. The broader impact on judicial ethics was equally significant. 2 months after the argument, the Supreme Court announced adoption of its first ever binding code of conduct, including stricter guidelines for public appearances and stronger recusal standards. While no justice commented directly on the connection to Crockett's argument, the timing led many observers to conclude that her powerful demonstration of the link between public statements and judicial impartiality had catalyzed long overdue reforms. In state legislatures across the country, lawmakers began re-examining voting procedures with renewed attention to disparate impacts. Several states proactively reformed voter identification requirements to ensure broader accessibility while maintaining security, citing the Supreme Court's new standard as guidance. Conservative legal scholars, initially defensive about Crockett's approach, gradually came to recognize the intellectual consistency of her originalist methods. At a Federalist Society conference the following year, prominent originalist Randy Barnett acknowledged, "Crockett has reminded us that intellectual honesty requires following historical evidence wherever it leads, even when it challenges our preferred outcomes." Her research into the original understanding of the Reconstruction Amendments deserves serious engagement from all constitutional scholars. The Crockett method, using rigorous historical research to illuminate the full context of constitutional provisions, became standard practice in major civil rights litigation. Law clinics at leading universities established projects dedicated to excavating similarly overlooked historical materials relevant to other constitutional questions. For ordinary Americans, especially in communities with histories of voter suppression, the impact was both practical and symbolic. Voter participation increased significantly in Jefferson County in the next election, with many first-time voters specifically citing the Crockett case as their motivation for engaging with the democratic process. This wasn't about partisan advantage, Crockett explained in a PBS Frontline documentary marking the first anniversary of the decision. It was about ensuring our Constitution fulfills its highest purpose, protecting the fundamental rights of all citizens, especially the right that preserves all others, the right to vote. When she returned to argue another case before the Supreme Court 2 years later, the atmosphere was markedly different. Justice Alito engaged respectfully with her arguments. Other justices referenced her previous historical research, and legal observers noted that the court's entire approach to voting rights questions had been fundamentally transformed. As constitutional law professors began teaching the case in their courses, they frequently emphasized that Crockett's most significant contribution wasn't just winning a specific case, but enlarging our understanding of what the Constitution means. By recovering the voices and intentions of the Reconstruction framers, she had helped restore a more complete vision of America's constitutional journey, one that recognized how each generation had expanded and deepened the promise of democracy. What began as a tense confrontation in the Supreme Court had evolved into something far more significant, a reminder that the Constitution is not frozen in 1787, but includes the transformative amendments that followed the Civil War. Amendments specifically designed to ensure that democracy would become more inclusive rather than less. Crockett hadn't just won an argument. She had helped recover a constitutional vision that had been obscured for too long, and her work would resonate in courtrooms and classrooms across America for generations to come. Her final line to the justices became a touchstone for discussions about constitutional interpretation. The framers of the 15th Amendment would recognize precisely what is happening today. The question is whether we possess the constitutional courage to see it as clearly as they did. It was a challenge not just to 9 justices, but to a nation still working to fulfill its constitutional promises. A challenge that would continue to resonate long after that momentous day in the Supreme Court.